The 1983 Code of Canon Law is the codification of canonical legislation for the Latin Church of the Catholic Church. It was promulgated on 25 January 1983 by John Paul II and obtained the force of law on the first Sunday of Advent 1983. It replaced the 1917 Code of Canon Law, promulgated by Benedict XV on 27 May 1917. History. The current Code of Canon Law is the second comprehensive codification of the non-liturgical laws of the Latin Church, replacing the Pio Benedictine Code that had been promulgated by Benedict XV in 1917. See also Canon Law, Codification and Code of Canons of the Eastern Churches. Pope John XXIII, when proclaiming a new ecumenical council for the Catholic Church, also announced the intention of revising the 1917 CIC. It was not feasible to revise the Code of Canon Law until after the conclusion of the Second Vatican Council, so that the decisions of the Council could guide the revision of ecclesiastical laws. Several of the Council documents gave specific instructions regarding changes to the organization of the Catholic Church. In particular the decrees Christus Dominus, Presbyterorum Ordinis, Perfecti Caritatis, and Ad Gentes. In 1966, Pope Paul VI issued norms to apply these instructions through the Motu Proprio Ecclesia Sancti, the Pontificia Commitia Codici Iuris Canonici Recognoscendo, which had been established in 1963. Continued the work of revising the Code of Canon Law through the pontificate of Paul VI, completing the work in the first years of the pontificate of John Paul II. On 25 January 1983, with the Apostolic Constitution Sacra Disciplina Leges, John Paul II promulgated the current Code of Canon Law for all members of the Catholic Church who belong to the Latin Church. It entered into force the first Sunday of the following Advent, which was the 27th of November 1983. In the Apostolic Constitution, the Pope described the new code as the last document of Vatican II. In 1998, Pope John Paul II issued the Motu Proprio ad Tuandam Fidem, which amended two canons of the 1983 Code of Canon Law and two canons of the 1990 Code of Canons of the Eastern Churches, so as to add new norms which expressly impose the obligation of upholding truths proposed in a definitive way by the magisterium of the Church, and which also establish related canonical sanctions. On December 15, 2009, Pope Benedict XVI issued the Motu Proprio Omnium in Mentem, which amended 5 canons of the 1983 Code of Canon Law, clarifying that, among those in holy orders, only bishops and priests received the power and mission to act in the person of Christ the head, while deacons obtained the faculty to exercise the diaconias of service, word, and charity. The amendments also removed formal defection from the Catholic faith as excusing Catholics from the canonical form of marriage. On 15 August 2015, Pope Francis issued the Motu Proprio Mitis Illudex Dominus Iesus, reforming the matrimonial nullity trial processes of the 1983 Code of Canon Law, dealing with declaring the nullity of marriage. The document was made public on 8 September 2015. While there have been many vernacular translations of the code, only the original Latin text has the force of law. Ecclesiological Inspiration of the 1983 Code. The Vatican II Decree Optatam Totius, in view of the decision to reform the existing code, laid down that the teaching of canon law should take into account the mystery of the Church, according to the dogmatic Constitution de Ecclesia. The 1917 Pio Benedictine Code was in fact structured according to the Roman law division of norms, persons, things, procedures, penalties, The 1983 Code, in total contrast, was deliberately given a much more doctrinal theological structure. Thus, it is configured, as far as possible, according to the mystery of the Church, the most significant books, 2, 3 and 4, corresponding to the Munus Regendi, the Munus Sanctificandi, and the Munus Docendi, which in turn derived from the kingly, the priestly and the prophetic roles or functions of Christ. John Paul II described the ecclesiological inspiration of the Code in this way. Structure in detail. The 1983 Code of Canon Law contains 1752 canons, or laws, most subdivided into paragraphs or numbers. Hence a citation of the code would be written as can. 934, 2, 1 degree. The code is organized into 7 books, which are further divided into part, section, title, chapter and article. Not every book contains all 5 subdivisions. This is the outline of the 7 books of the 1983 Code of Canon Law. Book I, General Norms, explains the general application of laws. Book II, The People of God, goes into the rights and obligations of lay people and clergy, and outlines the hierarchical organization of the Church. Book III, The Teaching Function of the Church, Christian Ministry, Missionary Activity, Education, and Social Communication. Book IV, The Sanctifying Function of the Church, Sacraments and Other Acts of Worship, Places of Worship and Feast Days. Book V, The Temporal Goods of the Church, Ownership, Contracts, and Wills, akin to the Civil Business Law. Book VI, Sanctions in the Church, Crimes and Punishment. Book VII, Processes, Trials and Tribunal. Summary. Book I, General Norms. This part of the Codex contains the general rules concerning legal sources, persons, governance and officers. Time. Legal sources are laws, which contain universal regulations, general decrees, instructions and statutes which refer to a special group, and in case of statutes are legislated by this group itself, and administrative acts, which only decide single cases. Persons are physical persons or juridical persons. In contrast with traditional secular legislation, not everybody is a physical person according to the Corpus Juris Canonici, because one is constituted a person with duties and rights only by christening. The Codex specifies conditions for the validity of a juridical act, especially in relation to form, coercion, misapprehension and lack of participation. Legal power is divided into the 3 authorities of legislative, executive and judiciary. The ability to conduct juridical acts can be attached to an office or it can be delegated to a person. Appointment and lot of ecclesiastical office are regulated. Time regulates prescription, which goes along with the national regulations, but can only be achieved in good faith, and definitions of time. Book II, The People of God. Book II describes the people of God. It discusses the general rights and obligations of members of the Church, and then discusses the ordering of the Church, from the Holy See to the local parish. The hierarchical constitution of religious and secular institutes and societies of apostolic life is shown to a degree adequate to explain the scope of applicability of the regulations of Part II. A religious institute is a society in which members, according to proper law, pronounce public vows. This book is divided into 3 parts. The Christian faithful, the hierarchical constitution of the Church, institutions of consecrated life and societies of apostolic life. The Christian faithful shows the obligations of the faithful in common, those of the lay and those of the sacred ministers or clerics, with special consideration of the formation and enrollment of clerics and personal prelatures. Furthermore, the associations of the Christian faithful, especially their recognition as a juridic person, are constituted, divided in public, private associations and those of the lay. Part II is entitled, The Hierarchical Constitution of the Church. This part describes the composition, rights and obligations of the supreme authority of the Church, consisting of the Roman Pontiff, the College of Bishops, the Synod of Bishops, the College of Cardinals, the Roman Curia and the Papal Legates. Furthermore, the dioceses, their organization with bishop, curia and synod, and their involvement in ecclesiastical provows and lead a life of brothers or sisters in common. A secular institute is an institute of consecrated life in which the Christian faithful, living in the world, strive for the perfection of charity and seek to contribute to the sanctification of the world, especially from within. Societies of apostolic life do not use a vow. Book 3. The Teaching Function of the Church. Book 3 describes the teaching function of the Church. The forms of teaching are the ministry of the divine word in the forms of the preaching of the Word of God and the catechetical instruction. The missionary action of the Church, the Catholic education in schools, Catholic universities and other institutes of higher studies, and the ecclesiastical universities and faculties, the instruments of communication and books in particular, and finally the profession of faith. Book IV. The Sanctifying Office of the Church. In Book 4, the function of the Church and its religious acts are explained. This book is composed of 3 parts: the sacraments, the other acts of divine worship, sacred places and times. The sacraments are baptism, confirmation, the Most Holy Eucharist, penance, anointing of the sick, holy orders and marriage. These sacraments are described with conditions, ceremony and participants. Other acts of divine worship are sacramentals, the liturgy of the hours, ecclesiastical funerals, the veneration of the saints, sacred images and relics, and the vow and oath. Sacred places are those which are dedicated for divine worship or for the burial of the faithful. The Code knows 5 kinds of sacred places: churches, oratories and private chapels, shrines, altars and cemeteries. Sacred times are feast days and days of penance. Book V. The Temporal Goods of the Church. This part of the Corpus Juris is the regulation of the civil law. There are instructions concerning the acquisition and administration of goods, especially the acquisition by bestowal either through an act inter vivos or through an act mortis causa, and contracts with special care of alimentation. Book V. Sanctions in the Church. Book V contains the canonical equivalent to secular criminal law. The book has 2 parts: delicts and penalties in general, penalties for individual delicts. The first part declares the necessity of a violation of a law and shows the limits and requirements of such a penal law. It determines reasons, which eliminate the punishment as lack the use of reason, nonage, mistake in law or facts, missing causality or intent, and self-defense. It also describes social cases as complicity, willful default and attempt. Possible penalties are censures, expiatory penalties and penal remedies and penances. Finally, the right of the application and cessation of penalties is regulated. The second part shows individual delicts, divided into delicts against religion and unity of the Church, those against ecclesiastical authorities and the freedom of the Church, those against special obligations, those against human life and freedom, usurpation of ecclesiastical functions and delicts in their exercise, and the crime of falsehood. In addition to these cases, the external violation of a divine or canonical law can be punished when the special gravity of the violation demands punishment and there is an urgent need to prevent or repair scandals. Book 7. Processes. Book 7 contains the legal procedure. It is divided in 5 parts. Trials in general, the contentious trial, special processes, the penal process, the method of proceeding in administrative recourse and in the removal or transfer of pastors. Part 1. The first part, trials in general, defines the court system, its 2 local instances, and the Roman Pontiff as the supreme judge with the representation by the tribunals of the Apostolic See, especially the Roman Rota. It determines the participants of the lawsuit, the judge, the auditors and relators, the promoter of justice, the defender of the bond, the notary, the petitioner, the respondent, and the procurators for litigation and advocates. Finally, it describes the discipline to be observed in tribunals, with the duty of judges and ministers, the order of adjudication, the time limits and delays, the place of the trial, the persons to be admitted to the court, the manner of preparing and keeping the acts, and the actions and exceptions in general and specific. Part 2. The contentious trial begins with the introductory libellus of litigation and the citation and notification of juridical act. The joinder of the issue occurs when the terms of the controversy are defined by the judge, through a decree of the judge. Further on, this part explains the trial of the litigation, especially the absence of a party, the intervention of a third person and the proofs. There are 6 kinds of proof: declarations of the parties, documents, testimonies, experts, judicial examination and inspection, and presumptions. After taking evidence, the acts are published, the case concluded and then discussed. The case ends with the sentence of the judge. The sentence can be challenged by complaint of nullity and by appeal. Finally, the res inducta and restitutio in integrum, the execution of the judgment. The judicial expenses and gratuitous legal assistance are regulated. As an alternative to this contentious trial, there is the possibility of an oral contentious process. Part 3 defines special processes and their special regulations, the process for declaring the nullity of marriage, cases of separation of spouses, process for the dispensation from a marriage ratum sed non consummatum, the process in the presumed death of spouses, and cases for declaring the nullity of sacred ordination. This part also shows methods of avoiding trials. Part 4 shows the proceedings of the penal process with the preliminary investigation, the trial, and the adhesive procedure. Part 5, the last part, shows the methods of proceeding in administrative recourse, which can be made by any person who claims to have been aggrieved by a decree, and the removal or transfer of pastors with display of the reasons for the removal or transfer. The final canon, 1752, ends with a reminder that the supreme law of the Church is the salvation of souls. Notable canons. Canon 97 reduces the canonical age of majority from 21 to 18, according to the consensus of civil law. Canon 332 governs papal resignations. Canons 823 to 824 decree that bishops are obligated to censor material concerning faith or morals. The implementation of Canon 915 is quite controversial. See the article Canon 915 for more information. Canon 916 decrees clergy in mortal sin are not allowed to celebrate Mass, and laypeople in mortal sin are not allowed to receive the Eucharist, except when they have a grave reason and there is no opportunity to confess, in which case they must make an act of perfect contrition and confess their mortal sins as soon as possible. Canon 919 decrees a 1-hour fast before the reception of the Eucharist.